Okay, so welcome back, students. This is lecture 4 of Law and Ethics for CMA Intermediate, June 2023 attempt. ठीक है, तो हम इंडियन कॉन्ट्रैक्ट एक्ट कर रहे हैं, ऑलमोस्ट लास्ट स्टेजेस में है. आफ्टर दिस द नेक्स्ट लेक्चर विल बी द लास्ट फॉर इंडियन कॉन्ट्रैक्ट एक्ट. ओके, सो लेट मी टेक यू टू वेयर वी हैड एंडेड लास्ट टाइम. ठीक है, यहाँ पे हमने एंड किए थे. So here we have to start contract, some special contracts. Okay, all these are special contracts. ठीक है, और इसमें से now we are going to do indemnity and guarantee first. ठीक है, ये एक टाइप ऑफ कॉन्ट्रैक्ट है, indemnity and guarantee. ठीक है, इंश्योरेंस टाइप के कॉन्ट्रैक्ट्स हैं. फाइन, दिस आर इंश्योरेंस टाइप ऑफ कॉन्ट्रैक्ट्स. एंड देन यू हैव bailment and pledge. We will see this. Okay, and laws of agency. This we will be doing in the next lecture. Okay, so we'll finish till pledge today. Okay, so pledge or bailment. So let us see. Okay, so after this we'll need another 1.5 hours to complete your contract. Fine. So now we are seeing indemnity and guarantee. Okay, so first we are seeing contract of indemnity. Okay, right. So this is chapter 8 of the Contract Act. Chapter 8 deals with indemnity and guarantee. Okay, so now first to start with, we're starting with indemnity, which are insurance type of contracts. Okay, that is given in sections 124 and 125. So you don't need to remember these sections. ठीक है, ये sections को याद रखने की जरूरत नहीं है. Okay, we just need to know the concept, right? So now what is a contract of indemnity? Okay, so in short, what I've told you, it is insurance type of contracts. Okay, contract by which one party promises to save the other, okay, from loss. Insurance में ही होता है, right? In insurance, one party promises to save the other from loss caused to him. ठीक है, अब loss किसकी वजह से हुआ है? Okay, loss caused by whom? Okay, it can be by the promisor or by any other person. Okay, so normally speaking, in insurance contracts, the loss is not caused by the promisor himself. Okay, so suppose you have taken insurance of accident insurance of let us say New India Assurance. Okay, you have taken the accident insurance. So now the loss, that the chance that the loss will be caused by this insurance company is almost negligible, correct? But the way your contract of indemnity is defined is loss may be caused by the promisor also. Loss can be caused by anyone. Okay, only thing is that the promisor will indemnify. So promisor is the insurance company here, is promising that I will indemnify. Oh, that means I will make good the loss. Okay, so this is the insurance company. Promisee is the client, okay, who has taken the insurance policy. He is the promisee. Okay, okay, right. So let's see an example. Okay, A contracts to indemnify B. Okay, so A is saying to B, I will indemnify you. Okay, so A is the indemnifier. Okay, so just think about the insurance company, that is the indemnifier, and the person who is getting money on damage is, okay, the insured in our common language, that is called as indemnified. Okay, so A contracts to indemnify B. So just for your thought, just think as A as the insurance company, B as the client. Okay, against the consequences of proceedings which C may take against B. Okay, in respect of sum of 2 lakhs. So C, there is a possibility that C will sue B. Okay, if he sues B, then the loss could be up to 2 lakhs. Okay, B might have to pay. There's a possibility. And A is now giving an insurance to B on that count. Okay, so this is a contract of indemnity. Right? It can be in many ways. Insurance, there are lots of insurance, right? You've got fire insurance, marine insurance, miscellaneous insurance, accident insurance, third party insurance, lots of insurance, types of insurance can be there. Okay. So now this contract includes indemnifier and the indemnity holder. So indemnity holder is also called as indemnified. Okay. Okay. So in our common language, indemnity holder or indemnified is the policy holder, insurance policy holder. Okay. That is the client of the insurance company. Right? A person who promises to indemnify from losses is called indemnifier, the insurance company. Okay. And person whose loss is made good, okay, as the indemnity holder. Okay. That is the person who is taking the policy is called as indemnity holder. Another word is indemnified. Okay. There's one more word for it, which is indemnified. Right? Okay. So the to indemnify does not merely mean to reimburse in respect of money paid. So meaning of indemnify is not just that you are giving back the money, but you are saving from loss. Okay. For here, the thing is some loss has happened and you are covering up for that loss. Okay. You might end up paying some money. Okay. That's another thing. Main thing in an insurance contract, the crux is that the insurer is saving the insured from a loss. Okay. Or will be saving in the future. Okay. ठीक है. सो चलिए, तो ये इतना पॉइंट मैं आपको जिसका क्रक्स हिंदी में भी मैं समझा देता हूँ कि क्या है. सो इंश्योरेंस कॉन्ट्रैक्ट में जो है उसको बोलते हैं हम लोग इंडेमनिटी, कॉन्ट्रैक्ट ऑफ इंडेमनिटी. ये क्यों किया जाता है? टू मेक गुड समवन्स लॉस. ठीक है. ओके. तो यहाँ पे आपका 2 पार्टीज होते हैं इस कॉन्ट्रैक्ट में, 2 पार्टीज. ओके. इंडेमनिफायर और इंडेमनिटी होल्डर. इंडेमनिटी होल्डर को हम इंडेमनिफाइड भी बोलते हैं. ओके. इंडेमनिटी होल्डर और इंडेमनिफाइड ये सेम वर्ड्स है. ठीक है. ओके. और यहाँ पे इंडेमनिफायर कौन है? मान लीजिए अपना इंश्योरेंस कंपनी. ठीक है. जो अगर इंश्योरेंस क्लेम आया तो उनको पैसा देना पड़ेगा. फाइन. तो ये है, यही बेसिकली हमारा शॉर्ट पॉइंट है कॉन्ट्रैक्ट ऑफ इंडेमनिटी का. ठीक है. तो ये काफी स्ट्रेट फॉरवर्ड माना जाता है. राइट. लेट्स गो अहेड नाउ. This contract of indemnity may be either expressed or implied. Okay. It can be expressed or implied. Okay. But it is normally expressed. Okay. So it is in the form of a document. Okay. As I said, no law prohibits anything which is oral. Okay. Anything which is oral. No law as such prohibits anything which is oral. Okay. यहाँ पे we are not talking about written and oral, we are talking about expressed or implied, which means implied means it is you can infer from the conduct of the parties that he has insured. Okay. So normal, technically, whatever insurance contracts you will find, they will all be expressed and in written. Okay. Fine. So ये जो था, it may be expressed or implied. ये case law है. Kuppan Chettiar versus Ramaswamy Chettiar. This is the case law. Okay. Okay. Then so next और एक case law है, New India Case Assurance Company Limited versus State Trading Corporation of India. Okay. Here it was held that almost all insurance other than life and personal accident insurance are contracts of indemnity. यहाँ पे इस केस लॉ में बोला था कि सारे इंश्योरेंस कॉन्ट्रैक्ट्स ऑफ इंडेमनिटी होते हैं एक्सेप्ट लाइफ और पर्सनल एक्सीडेंट्स। तो क्यों लाइफ और पर्सनल एक्सीडेंट को अलग रखा गया? रीजन ये है कि मान लीजिए किसी का डेथ हो जाता है, ठीक है, LIC से ही विल गेट कॉम्पेंसेशन, ठीक है। लेकिन क्या ये आप बोल सकते हैं कि उस जब वो पैसे मिलते हैं उसको ये बोल सकते हैं कि उसके लाइफ की कीमत वो पैसे थे? ऐसा हम नहीं बोल सकते, करेक्ट? राइट, इसलिए यू कैन नॉट से दैट यू आर इंडेमनिफाइंग द लॉस ऑफ हिज लाइफ, ठीक है। तो इसीलिए लाइफ इंश्योरेंस को कॉन्ट्रैक्ट ऑफ इंडेमनिटी नहीं माना जाता, ठीक है, बिकॉज यू आर नॉट मेकिंग गुड द लॉस, आप उसके लाइफ की कीमत नहीं लगा सकते, ओके। वैसे ही पर्सनल एक्सीडेंट में भी, ओके, कोई वर्कर का राइट हैंड कट गया, ठीक है, तो आप कुछ पैसे से उसका मोल नहीं लगा सकते एक्चुअली, राइट। जो इवन कॉम्पेंसेशन वगैरह मिलते हैं, दैट इज जस्ट टू मिनिमाइज हिज लॉस, करेक्ट। तो इसीलिए योर लाइफ एंड पर्सनल एक्सीडेंट इंश्योरेंस आर कॉन्ट्रैक्ट्स ऑफ आर नॉट कॉन्ट्रैक्ट्स ऑफ इंडेमनिटी, ठीक है, ओके। क्योंकि इसमें आप लॉस को भरपाई नहीं कर रहे हैं, बेसिकली यू आर जस्ट मिनिमाइजिंग द पेन, ठीक है। चलिए, फाइन। सो देन अनदर केस लॉ, नेशनल ओवरसीज वर्सेस एक्सपोर्ट क्रेडिट गारंटी कॉर्पोरेशन, ओके, दिस इज अनदर केस लॉ। इसमें क्या है, इसमें क्या हुआ था कि व्हाट वाज हेल्ड इज, if the export risk policy was not followed, corporation is not liable to indemnify loss to exporter. So here what was told or what was established यहाँ पे, that is the insurance policy might have certain conditions, correct? Now, if the insured doesn't follow the conditions, then the insurance company is not bound to pay. Okay? The conditions must be followed. Here there was an export risk policy, okay, which had to be followed by the national overseas company. Okay? So they had to follow an export risk policy. They didn't follow. Okay? Then they had some loss or something, and so here the Export Credit Guarantee Corporation, okay, this was the insurance company in this case, it refused from payment, right, and court held that it is okay, is right, okay. So always इसमें से हमने क्या सीखा यहाँ पे कि one thing always that you should the insured or the indemnified, ठीक है, यहाँ indemnity holder, ओके, और बोलिए इंश्योर्ड, सब एक ही सेम वर्ड से, ओके। सो दे मस्ट फॉलो, ओके, they must follow the policy. There will be some rules of the policy, right? There are some rules always. For example, in accident insurance, you cannot drink and drive. If you have drunk and driven, then you will not get the insurance amount, correct? As a, there are some rules always, okay, of the policy. The rules must be followed. If not, you will not get the indemnifier is not bound to indemnify you, okay. Rules must be followed, ठीक है, fine. So let's go ahead now, okay. Now rights of the indemnity holder when sued, okay. So यहाँ पे what will happen is, many times the indemnity holder will be sued by someone who is affected. यहाँ पे इंश्योरेंस में, ठीक है, जैसे थर्ड पार्टी इंश्योरेंस भी से, राइट, if the third party has suffered some damage, they can sue the insured, okay, or the indemnity holder, ठीक है. So what are his rights in that case, okay, that's what we are seeing. The promisee in a contract of indemnity is entitled to recover. Who is the promisee? Promisee is the insured or the indemnity holder, okay, or the indemnified. So promisee is entitled to recover Okay, recover from whom? From the insurer. Okay, from the indemnifier. All damages which he may be compelled to pay in a suit in respect of any matter, okay, to which the contract applies. Okay, so if say the third party has brought a suit, and as per the suit, this person had to pay him some damages. Okay, if the amount is within the policy, he is entitled to claim it. Okay, right? So third party suits, if he has to pay any damages because of third party suits, he can claim it from the insurer. Okay. Of course, it will depend on the policy. As I said, there are different types of policy, right? As you all would be taking a two-wheeler policy at least. Okay, so there are some comprehensive policies, then third party losses. For that, you have to pay some extra premium. Yes, all those things will be there. Okay, but if you have the right kind of policy, and if someone, a third party, brings a case on you, then you can claim it from the insurer. Okay, all costs which he may be compelled to pay in any suits, in bringing or defending it. Okay, and he did not contravene any orders of the promisor and acted prudently. Okay, so here ये है कि all incidental costs, okay, for defending the suit. Okay, he might have to incur some court charges, this, that. Okay, all those charges will also be part of the insurance arrangement. So those become incidental charges. Okay, that will be called as incidental charges. Okay, and then next, all the sums which he may have paid under the terms of any compromise. So sometimes what happens, you normally these things happens when accidents and all take place, right? So before going to the court, both the parties speak and they arrive at a common compensation amount, which is called compromise. So if he has arrived at compromise amount, okay, right, and the compromise was not contrary to the orders of the promisor, so that he can compromise, and the compromise is prudent in this case. It is not against the orders of the promisor of the indemnifier. So indemnifier, if he specifically in the contract mentions that he cannot enter into a compromise, that is another thing. Okay, otherwise he can enter into a compromise where compromise is reducing the liability, right? When do you go for a compromise? Okay, if say there is an accident, and if the person goes to court, say he will have to pay 5 lakhs. Okay, but the other person also knows that he will have to spend a lot of time, energy in the court. So he is saying, okay, you give me 2 lakh and I will not press charges. Okay, and you have agreed. So this 2 lakh is nothing but compromise. Okay, this 2 lakh is nothing but compromise, right? Fine. Okay, so this section is not exhaustive, which means there can be more similar things also. The only thing which needs to be seen is he must have acted prudently. Okay, so prudently means in a way that the overall expense of the indemnifier must not increase but must have reduced, right? Like in this case, in the example we took, okay, here his here what he has done by compromise, that he has reduced the indemnifier's expense. Otherwise, the case would have gone on. The insurance company would have had to pay 5 lakhs. Okay. Okay. So these are the 3 points: rights of indemnity holder. Okay. So even before the damage is incurred, it is open to him to sue for specific performance of the contract of indemnity if shown that an absolute liability has been incurred by him and that the contract of indemnity covers such liability. That means, what is the meaning of this? Okay, sometimes the final proof that say your goods have been lost is not yet there. Okay, for example, your consignment is going in a ship. Okay, Now the ship has sunk, right? The ship has sunk with a possibility of only, let us say, 5% things which can be retrieved. 5% retrieval is possible. It has sunk. So, but now you do not have a direct information that your goods have been lost also. Okay. But you know that the ship is sunk. So just on the premise of the ship is sunk, you can uh, claim from the insurance company. Fine. This is what this point says. It is open to sue for specific performance, means asking the insurance company to perform his contract of indemnity. That is to pay compensation. Okay. If shown that an absolute liability has been incurred, absolute liability means the ship has sunk. Okay. Right. And that the contract covers such liabilities. In Pepin versus Chandra, okay, regarding liability indemnified to a third person, okay, cost of resisting or reducing claim may be recovered. Okay, so here what it was said is, in this case, again kind of a compromise. Okay, when he has incurred cost to reduce the claim, that can be, okay, recovered, right? So understood. That is the thing here. So actually, when can you really press charges against the insurance company for compensation? Okay, when your loss happens 100%. Loss happens, okay, and this is 100%. Like now it is known that the loss has happened. Okay, only then they will start processing the claims. So here in this point, what is said is, although you do not 100% know that now your whatever your goods have been lost or not, right? But you know that the ship has sunk. So chances that your goods will be retrieved will be very less. Okay. So when something absolute happens and your loss is a subset of that, is a part of that, okay, then that is enough for you to ask the insurance company for damages. Okay. Fine. So that was contract of indemnity. Okay. There's nothing much in that. Okay. It's a small thing actually, a contract of indemnity. Fine. So next is contract of guarantee. Okay. Next part is, we saw contract of indemnity and contract of guarantee. Okay. So indemnity is over. The second part is now contract of guarantee. Okay. So here there is a contract to perform the promise or discharge liability of a third person in case of default. Okay. So here, so you would have heard about guarantee, I'm very sure, right? Guarantee is something which we all know about, right? Even while we talk normally, we say, "Ye apni guarantee, मैं guarantee देता हूँ," we say. Even when you don't mean seriously, we talk about the word guarantee always. Okay. So guarantee means when one person says that if anything wrong happens, I am there to make good the loss. Okay. Okay, so that he is called as guarantor, that person. Okay, so that is the law of guarantee. Okay, so a contract to perform the promise or discharge the liability of a third person in case of default. That is, there will be first person, there will be second person. Okay, so let me just show you the components and then I will give you the example, because if I use these words, you will not understand. Okay. So who are the parties? Components means parties. Okay. One is surety. Person who gives guarantee is called surety. Okay. And the surety is guaranteeing someone. Okay. The person for whom he is guaranteeing is the principal debtor. Okay. He is the person, like, he is guaranteeing. And this principal debtor will have a creditor. So this surety is guaranteeing the creditor. Okay. So basically, you have got three parties. Fine. One is, okay, surety. Okay, he is the guarantor. Okay, and before surety has come in, there is already a contract between principal, debtor and creditor. Okay, there is already a contract between principal, debtor and creditor. Fine. So now, but the creditor says that I will not have contract with you. So say, let us say this debtor does not have good credit worthiness. So he says, bring me someone who will guarantee. In case, I face any loss, then there should be some guarantor who will make good the loss. Then principal debtor will speak to someone he knows, okay, to guarantee him. So that person is called as surety. Okay. So surety is, in our layman language, is the guarantor. Okay. So if surety says okay, then there is a contract of guarantee, okay, in this regard between surety and creditor. Okay. So in this case, basically there are contracts among all three parties. Okay. Surety and guarantee, there is a guarantee contract. Among these two, there is already a contract, okay, to start with. Right? And the principal debtor is the person who has approached the surety. So there is a kind of a contract between principal debtor and surety also. So there are these three parties to the contract of guarantee. Okay. One thing to remember here is, in contracts of guarantee, the role of surety will come only when there is a loss. Otherwise, it will not. Okay. Okay. So what happens in contracts of guarantees in commercial parlances? In about 95% of the cases, the guarantee is not invoked. Okay. You have to give a guarantee, okay, in many cases, but there is no default and the guarantee is not invoked in 95% of the cases. The guarantee will be invoked only when there is a default by principal debt. फाइन, ठीक है. तो यहाँ पे देखिए, ये आपके कॉन्ट्रैक्ट ऑफ गारंटी में 3 पार्टी होते हैं. ठीक है. कॉन्ट्रैक्ट ऑफ इंडेमनिटी में 2 पार्टीज होते हैं. ठीक है. राइट. और ये कॉन्ट्रैक्ट ऑफ गारंटी में 3 पार्टीज होते हैं. हमेशा आपको याद है, गारंटी है, आपको इमीडिएटली ये तो याद रहेगा, एक गारंटर रहेगा. गारंटर कोई किसी एक पर्सन को वो गारंटी कर रहा है. ठीक है. किसी एक पर्सन के बिहाफ में गारंटी दे रहा है. ठीक है. तो जो गारंटर है उसका नाम है श्योरिटी. ठीक है. जो गारंटर होता है आपका, गारंटर का नाम है श्योरिटी. श्योरिटी बोलते हैं. ठीक है. और ओरिजिनली एक ट्रांजैक्शन रहेगा प्रिंसिपल डेटर और क्रेडिटर में. इन क्रेडिटर कंफर्टेबल नहीं रहेगा इसको गुड्स देने के लिए या कुछ, मतलब मे बी ही इज अ न्यू बिजनेसमैन, व्हाटएवर. ही सेज ब्रिंग मी अ गारंटर. सो प्रिंसिपल डेटर जो है, he goes to someone he knows जो है श्योरिटी. इसको बोलता है आप मुझे गारंटी दो. ठीक है. तो ये इसको गारंटी दे देगा. और अच्छा, ठीक है. तो श्योरिटी क्रेडिटर से बात करेगा, ये दोनों में आपस में कॉन्ट्रैक्ट होगा, गारंटी का कॉन्ट्रैक्ट. ओके. यहाँ पे 3 कॉन्ट्रैक्ट्स होते हैं एक्चुअली श्योरिटी में. अच्छा, आप ये बोलोगे कि अब श्योरिटी क्यों उसको गारंटी दे रहा है. ठीक है. मान लीजिए 5 लाख का गारंटी दिया, अगर इसने डिफॉल्ट कर दिया, इसका तो लॉस हो गया ना श्योरिटी का. करेक्ट. तो जब श्योरिटी लॉस को मेक गुड करता है, मान लीजिए 5 लाख का डिफॉल्ट कर दिया प्रिंसिपल डेटर ने. ओके. 5 लाख का डिफॉल्ट कर दिया प्रिंसिपल डेटर ने. ओके. तो अभी क्रेडिटर क्या करेगा? क्रेडिटर श्योरिटी के पास जाएगा. ठीक है. बोलेगा कि डिफॉल्ट हो गया है, आप मुझे ये पैसे वापस करो. अब श्योरिटी का कॉन्ट्रैक्ट है, उसको करना पड़ेगा. ठीक है. श्योरिटी विल गिव हिम 5 लाख रुपीस. ठीक है, देना पड़ेगा. अब ये जो 5 लाख है, अब श्योरिटी जो है इससे रिकवर कर सकता है फ्यूचर प्रिंसिपल डेटर्स. इसलिए कोई फ्री में कुछ नहीं करेगा. श्योरिटी तभी श्योरिटी उसी को देगा जिसका जिस पे उसको भरोसा है। ठीक है, तो श्योरिटी जो है ये 5 लाख बाद में प्रिंसिपल डेटर से रिकवर कर सकता है। यानी होता ये है इस कॉन्ट्रैक्ट में एक्चुअली क्रेडिटर रिप्लेस हो जाता है। तो इसको, इस क्रेडिटर को अपने पैसे मिल गए, ये पिक्चर से आउट हो गया। ठीक है, अब ये बन गया क्रेडिटर, और ये तो डेटर का डेटर ही रहेगा। ओके, सो दिस इज व्हाट हैपेंस इन कॉन्ट्रैक्ट ऑफ श्योरिटी। अच्छा, ये भी इट कैन बी ओरल और रिटन। जैसे मैंने बोला आपको कि लॉ जो है इट डजंट से नो टू एन ओरल कॉन्ट्रैक्ट। ठीक है, तो आप ओरल का कभी भी कॉन्ट्रैक्ट कर सकते हो, बट द प्रॉब्लम इज दैट इट इज डिफिकल्ट टू प्रूव, हेंस इट इज नॉट डन, राइट। तो इट इज अ ट्राइपार्टाइट एग्रीमेंट। ये सब छोटे मोटे इसमें आ सकता है, और ऑब्जेक्टिव टाइप क्वेश्चंस वगैरह में यू कैन हैव इट। ठीक है, विच इज अ ट्राइपार्टाइट एग्रीमेंट। तो आपको 2-3 टाइप के कॉन्ट्रैक्ट्स दे देंगे। ओके, तो उसमें दिस वन कॉन्ट्रैक्ट ऑफ गारंटी इज अ ट्राइपार्टाइट एग्रीमेंट वेयर यू हैव गॉट 3 people। ओके, 3 parties। अच्छा, अब कंसिडरेशन फॉर गारंटी। ठीक है, हमने पढ़े हैं कि फॉर for every agreement consideration is essential, correct? Without consideration there can be no contract। ठीक है, no consideration no contract, right? तो अब जब ये इसको गारंटी दे रहा है, अब बात ये आती है कि जब श्योरिटी आपका, ठीक है, when the surety, okay, is guaranteeing the principal debtor। ठीक है, यहाँ पे क्रेडिटर, ठीक है, here there is principal debtor। ठीक है, तो यहाँ पे आपका जो श्योरिटी है, तो ये श्योरिटी बोल रहा है कि मैं आपको पैसे दे दूंगा। ठीक है, मैं आपको पैसे दे दूंगा, आप इसके साथ कॉन्ट्रैक्ट कर लो। ओके, सो नाउ व्हाट इज द कंसिडरेशन फॉर श्योरिटी, बिकॉज बात ये आ रही है इस कॉन्ट्रैक्ट में, व्हाट इज द कंसिडरेशन। सो लॉ सेज दैट व्हेन ही सेज दैट श्योरिटी अप्रोचेस द क्रेडिटर सेइंग you should please continue with the contract with him, I will guarantee that he repays your amount। ठीक है, so based on what he has requested, great creditor is saying okay, so now I promise to go ahead with his contract। so ये जो promise है ना, that the creditor says that I promise to go ahead with the contract, this is consideration for surety। okay, ये होता है आपका consideration for surety। ठीक है, अच्छा, तो इसको बोलेंगे गारंटी कंसिडरेशन। ठीक है, तो विच इज रिसीव्ड, विच इज फॉर द श्योरिटी, एनीथिंग डन और प्रॉमिस मेड फॉर द बेनिफिट ऑफ द प्रिंसिपल डेटर। ठीक है, फॉर द बेनिफिट ऑफ द प्रिंसिपल डेटर इज creditor is saying I am ready to go ahead with the contract, may be sufficient consideration for surety। ठीक है, so let's see some examples here। ठीक है, so first one is B requests A to sell and deliver to him goods on credit। ठीक है, so B is the debtor here, he is requesting A to sell and deliver goods on credit। क्या मेरे को, you give me goods on credit। so B is saying, telling A that please give me goods on credit to sell। ठीक है, A agrees to do so। okay, A agrees to do so। ठीक है, provided C will guarantee, third person, provided the third person will guarantee it। ठीक है, creditor is asking for guarantee, fine, for the price of the goods। C promises to guarantee। ठीक है, right, C says okay I will guarantee and you promise to deliver the goods। ठीक है, so this is sufficient consideration for C's promise। यहाँ पे जो ऊपर देखे हमने वही, fine, it's just an example। now another thing, A sells and delivers goods to B। now A is the seller, okay, he is delivering goods to B। ठीक है, so C afterwards request A ये हो चुका, दिस इज हैपेंड नाउ. C later on requests A to forbear to sue B. So इसका मतलब ये है, is asking to forbear to sue B means A sells and delivers goods to B. ठीक है, और B ने उसका पेमेंट नहीं किया. B has not paid him for that. ठीक है, so A wanted to sue him. That is understood in this question by this line. C afterwards requests A to forbear to sue B for the debt for a year. So C is requesting, don't sue him. Okay, give him 1 year's time to pay. And he promises that if he agrees, then after in 1 year, if he doesn't pay, then C is ready to pay the amount. So C is ready to guarantee. Okay, so A agrees to forbear. Okay, so this forbearance is sufficient consideration for C's promise. So forbear मतलब जैसे नाम यही पता चल रहा है आपको, bear यानी बर्दाश्त करने के लिए आप एग्री कर रहे हो. ठीक है, मैं थोड़े दिन और रुक जाता हूँ. ठीक है, तो आप जब बर्दाश्त करते हो उसके लिए वर्ड है forbearance या forbear. ओके, देन A sells and delivers goods to B. Okay, A is creditor, B is debtor. Okay, C afterwards without consideration agrees to pay for them in default of B. ठीक है, agreement is void. अब ये समझना जरूरी है कि क्यों void है करके. Okay, so here the thing is there needs to have an agreement between surety and the creditor. ठीक है, if there is no talk between surety and creditor, surety is just unilaterally saying that okay, I will give, don't worry. He's telling the debtor, if something happens, I will take care. Okay, if he's saying that, right, then he has not entered into a promise with the creditor. He's only telling the debtor. So then there is no contract between surety and the creditor. Okay, that's the problem here. So without consideration agrees to pay means consideration क्या था? Consideration was always the creditor's promise. ठीक है, for creditor's promise, your surety was giving a guarantee. Okay, so यहाँ पे without consideration means इसका मतलब ये आता है कि there is no agreement between the creditor and the surety, hence it is void. Okay, fine. चलिए next. Not necessary that consideration should be received by the surety. ठीक है, यानी consideration इसको he will receive इसका ऐसा कोई जरूरी नहीं है. ठीक है, तो ओनली बस प्रॉमिस तक इनफ है. लेटर ऑन देयर विल बी ट्रांजैक्शन बिटवीन योर प्रिंसिपल डेटर एंड द क्रेडिटर. उनके बीच ट्रांजैक्शन हुआ, दैट इज सफिशिएंट फॉर हिम. ठीक है, तो वो कंसिडरेशन ये इसको मिलेगा ऐसा कुछ नहीं. ही डजंट नीड टू टेक एनीथिंग फ्रॉम द क्रेडिटर. ठीक है, so consideration between principal debtor and creditor is good consideration for surety. वही उसी चीज को अलग ढंग से बताया है. Same thing they are presented in a different way. Okay, so basically consideration for surety is only the promise from the creditor that he is okay to continue with the contract with the principal debtor. Okay, then after that all exchange of money and all will happen between principal debtor and creditor. Surety will not be involved. He will be invoked only when there is default. Okay, by the principal debtor. Now there's one more case law, Rajendra versus Mahila Chandrabai. Okay, so यहाँ पे what happened is no promise was made directly between creditor and surety. ठीक है, इस केस में हुआ क्रेडिटर और श्योरिटी के बीच में, ये श्योरली नहीं है, हम श्योरली लिखा है ना, इस श्योरिटी. Okay, so there was no promise between creditor and surety. ठीक है, so if there is no direct promise between the two, then the contract becomes void. That's what we have seen earlier. So इस case law में इसको establish किया गया. In this case law it is established. Okay, we're doing it in very detail. Okay, we're considering almost all case laws which are there in your study material. Okay, and we're going through each sentences because then in the exam you have to write these sentences only, correct? if not the exact sentence, something close to that. So which is why, we are not kind of removing the text and just giving you something objective. Okay, then it becomes hard to write. इसीलिए एक एक we are going line by line. Okay, ठीक है. और इसमें भी anything which is certain things are little exaggerated, which is not required by us. Oh, those things we screen off. ठीक है, to make it even more intelligible. Right. So then next जो है is another case law, United Breweries versus KSII and DC Limited. Okay. यहाँ पे what was said, guarantee depends upon the terms under which the guarantor binds himself. Okay. He cannot be made liable for more than what he has undertaken. Okay. So what was said here is, if the guarantor is saying that I undertake to pay up to 50,000, then he cannot be forced to pay more than 50,000. Okay. Whatever the guarantor is binding himself, only that will be his liability. Okay. Fine. So now we have reached a place where we can talk about distinction between indemnity and guarantee. Then all these, where you have got two things, okay, distinguish between is a very common question. Okay. So in your contract of guarantee, okay, yeah, contract of indemnity we have read, contract of guarantee, okay. सारे जो contracts whatever we are going to learn also, there's a good chance that you will get distinguished between. It's a very common question in this part. Okay. So now if you know what is indemnity, what is guarantee, you can yourself create your 4 points. Okay. So let's see. So first thing is, okay, contract of indemnity. Okay. There are two parties. Okay. The indemnifier and the indemnified. Okay. There are two parties, indemnifier and the indemnified. ठीक है. और यहाँ पे 3 parties होते हैं, हमने देखा. Okay. That is principal debtor, surety and creditor. ठीक है. Principal debtor, surety and creditor for guarantee. और इसमें indemnifier, okay, and the indemnified. ठीक है. Fine. Indemnifier and the indemnified. Right. और यहाँ पे who primary liability किस पे है? The insurer has the primary liability, correct? So primary liability is on the indemnifier. Here primary liability is on the principal debtor, secondary on the surety. Right? The next is indemnifier is not acting at the request of the debtor. ठीक है. तो ये एक पॉइंट क्या होता है ना, इन योर इंश्योरेंस कॉन्ट्रैक्ट, ऐसा इन इंश्योरेंस it's not that whenever claim has been made only then he is liable. ऐसा नहीं होता. Okay. If the insurer also comes to know that some contingency has happened, okay, they have to unilaterally initiate the payment. Okay. So ऐसा नहीं है कि insurer will wait. ठीक है. Procedure is, yes, wherever possible, debtor will lay a claim and he have to give. But it is not that if he doesn't lay a claim, indemnifier does not have a liability. ऐसा नहीं होता. Okay. So which is why indemnifier is not acting at the request of the debtor. और here जो है, surety always requests the principal debtor. We had seen, correct? Surety gives contract at the request of the principal debtor, right? First principal debtor initiates it. Then there is a contract between surety and the creditor. Okay. ठीक है. तो यहाँ पे the next is, so possibility of a loss. Okay. ठीक है. The possibility of any loss happening, ठीक है, is the only contingency against which indemnifier undertakes to indemnify. So आपका जो indemnifier है, ठीक है, तो ये what is the contract of indemnity? It is basically an insurance contract, correct? So पॉसिबिलिटी ऑफ लॉस इज द प्रेमिस फॉर दैट कॉन्ट्रैक्ट, ठीक है। अगर ये लॉस होगा तब हम आपको पैसे देंगे, उसके लिए यू पे दिस मच प्रीमियम, करेक्ट। तो पॉसिबिलिटी ऑफ लॉस is the only contingency against which the indemnifier will pay the amount to indemnity holder, ठीक है। ओके, एंड यहाँ पे सो इफ अगर लॉस नहीं हुआ तो नहीं, नाउ हम लोग कितने इंश्योरेंसेस लेते हैं, राइट, वी लॉट्स ऑफ इंश्योरेंस वी बाय, ओके। हाउ मेनी टाइम्स हैव यू बीन एबल टू क्लेम? वेरी फ्यू टाइम्स, करेक्ट, वी डोंट नॉर्मली क्लेम, क्योंकि लॉस होगा ऐसा चांस कम होता है, राइट। द चांस इज लेस दैट देयर विल बी अ लॉस। सो इफ देयर इज नो लॉस देन योर indemnifier doesn't have to pay anything, ठीक है। सो यहाँ पे but there is already an existing debt, okay, there is an existing debt for which the surety gives guarantee to the creditor, ठीक है, on behalf of the principal debtor. So in the end this existing debt has to be paid, okay, by the principal debt, ठीक है। यहाँ पे payment will happen only on loss, that is one major difference, okay। So then indemnifier cannot sue the third party, ठीक है, indemnifier cannot sue third party. If there is a loss to third party, there is no contract between the indemnifier and the third party, so they cannot sue unless there is something called assignment that the insurer, okay, is making the sorry, the insured is making the insurer his representative, that is called as assignment. If they do assignment, only then the insurer can sue the third party, otherwise there is no contract between the insurer and the third party यहाँ पे, okay। और here it's not like that, the surety is entitled to proceed, ठीक है। Here the surety is entitled to proceed against the principal debtor, ठीक है, when he is obliged to perform the guarantee, ठीक है। surety after paying the guarantee amount he can go back to the principal debtor and ask for the amount, ठीक है। as I said, creditor gets replaced, ठीक है, क्रेडिटर को उसका ड्यू मिल जाता है और जो आपका श्योरिटी है वो क्रेडिटर बन जाता है आपका प्रिंसिपल डेटर का, ओके। चलिए, द नेक्स्ट कॉन्ट्रैक्ट इज बिटवीन इंडेमनिफाइड, ओके, इंडेमनिफायर एंड द इंडेमनिफाइड, ठीक है। कॉन्ट्रैक्ट इज बिटवीन द इंडेमनिफायर एंड द इंडेमनिफाइड, ओके। दो पार्टीज है यहाँ पे, थ्री पार्टीज है, two contracts, three pairs of contracts यहाँ पे, ठीक है। there are three pairs of contracts between principal debtor and creditor, ठीक है, surety and creditor, and principal debtor and surety, all three have contracts, fine, okay। now next is liability of surety, ठीक है। next is liability of surety. it कब आएगा हमने अभी देखे थे, okay, only when principal debtor fails to pay the debt, okay? Otherwise there is no liability of surety, okay। so liability of surety is coextensive with that of principal debtor unless otherwise provided. इसका मतलब ये है कि whatever is the liability of the principal debtor, ठीक है, that is the liability of the surety, okay। इसका मतलब है it is coextensive. इसका मतलब जो है we'll see with this example, okay। यहाँ समझ में आएगा आपको, ठीक है। A guarantees to be payment of a bill of exchange to exchange by C, ठीक है। A guarantee कर रहा है to B, so A is the surety, B is the creditor, ठीक है। और what is being guaranteed? C, that C will pay a bill of exchange to B, ठीक है। तो bill is dishonored by C. If bill is dishonored, A is liable for bill amount plus noting charges वगैरह, ठीक है। So what is the total due on C, ठीक है। कभी भी it will not just be the debt amount, it can be some other charges, correct, गवर्नमेंट टाइप के जो चार्जेस होते हैं like noting charges वगैरह, सो वट एवर इज विल बी द लाइबिलिटी ऑफ द डेटर, ठीक है, वो जो आफ्टर वो इंस्टेंस हो जाता है, ओके, दैट इंस्टेंस हैपेंस, ओके, इंस्टेंस ऑफ डिफॉल्ट, ठीक है, तो क्या होगा उस वक्त जो रियल लाइबिलिटी रहेगी, ओके, दैट विल बी द लाइबिलिटी ऑफ द गारंटी, ठीक है। यहाँ पे इट इज नॉट जस्ट द बिल अमाउंट बट ऑल्सो द नोटिंग चार्जेस। तो इसके लिए ये बोला गया, फॉर दिस इट हैज बीन सेड दैट liability of the surety is co-extensive with that of the principal debtor unless otherwise provided, ठीक है। सो अगर ये कर सकता है, बिकॉज श्योरिटी कैन ऑलवेज, surety cannot be asked to pay more than what he has bound himself. Surety can say, okay, my liability will only be bill amount, not any other amount. If he expressly states that, then his liability will be only the bill amount. Otherwise, it will be co-extensive with the debt of the principal debtor, ठीक है, क्लियर। तो ये चीज है। अच्छा, श्योरिटीज लाइबिलिटीज इमीडिएट, दिस इज वन केस लॉ, गौरी प्रसाद वर्सेस रैबो इंडिया फाइनेंस लिमिटेड, ठीक है। श्योरिटी लाइबिलिटीज इमीडिएट है ना, जैसे लॉस हुआ क्रेडिटर को इमीडिएटली श्योरिटी का लाइबिलिटी आ जाता है, देयर इज नो टाइम लैग, ओके। श्योरिटीज लाइबिलिटीज इमीडिएट। अनदर केस लॉ इज स्वामीनाथ पिल्ले वर्सेस लक्ष्मण अय्यर, स्वामीनाथ पिल्ले वर्सेस लक्ष्मण अय्यर, ओके। It is not correct that creditor cannot proceed against the surety unless he has first exhausted all his remedies against the principal debtor. तो यहाँ पे ये बोला है इस केस लॉ में, क्या बोला गया है, creditor cannot proceed against the surety unless he has first exhausted all his remedies. ऐसा नहीं, मतलब, ठीक है। फॉर एग्जाम्पल प्रिंसिपल डेटर इज, यहाँ पे हियर इज योर प्रिंसिपल डेटर, ठीक है, हियर इज योर श्योरिटी, ठीक है, यहाँ पे एक बॉन्ड है, ठीक है, ठीक है, इसने ही हैज डिफॉल्टेड, ठीक है। प्रिंसिपल डेटर का मान लीजिए, प्रिंसिपल डेटर का और एक एस्टेट और सम अदर बिजनेसेस, ठीक है, बट दिस गारंटर जो है, ये श्योरिटी जो है, इसने बॉन्ड को गारंटी किया, हैज गारंटीड द बॉन्ड, ओके, एंड प्रिंसिपल डेटर ने क्या किया, ही हैज डिफॉल्टेड, डिफॉल्ट कर दिया बॉन्ड, ठीक है। तो ये पॉइंट ये बोल रहा है आपका कि अब ये डिफॉल्ट कर दिया ना, तो ये सीधा इससे जाके मांग सकता है पैसे, ओके। अब इसका इसके लिए ये जरूरी नहीं कि अच्छा यहाँ डिफॉल्ट होगा तो फिर इसके दूसरे स्टेट में जाए, यहाँ से ट्राई करे, यहाँ से मिल जाए इसके, और गो टू सम अदर बिजनेस ऑफ प्रिंसिपल डेटर एंड ट्राई टू गेट दैट मनी, ठीक है, वो काम इसका नहीं, क्रेडिटर का। इफ द गारंटी हैज बीन गिवन फॉर द बॉन्ड, ठीक है, इफ द bond is not paid, default happens, he can straight away go to the surety. He doesn't need to go to some other related businesses or related people of the principal debt, ठीक है। ऐसा नहीं है कि सारे इसके जहां जहां से पैसे मिल सकते हैं सबका दरवाजा खटखटाएगा वो, और जब नहीं हुआ तभी श्योरिटी के पास जाएगा, ऐसा नहीं, ठीक है। अगर ये इसने नहीं दिया तो और क्या क्या है इसका वो सोचने की भी जरूरत नहीं, गो स्ट्रेट अवे टू द श्योरिटी, ओके, गॉट इट। चलिए, ओके, सो दिस इज वन मोर थिंग। चलिए, देन अनदर थिंग इज इफ लेटर ऑफ गारंटी, ठीक है, guarantee is only the principal sum not interest, guarantee is only for principal sum, then he is not liable to pay interest. So ये याद रख लीजिए जस्ट कि द गारंटर, ठीक है, गारंटर विल ओनली पे व्हाट ही हैज बाउंड हिमसेल्फ विथ, ठीक है, व्हाट ही हैज नॉट बाउंड हिमसेल्फ उसके ऊपर उसका लाइबिलिटी नहीं, ठीक है। इन दिस केस ही सेड आई विल पे ओनली प्रिंसिपल, so then creditor cannot ask for interest, okay। चलिए, the next thing is continuing guarantee, okay। So next basically is what is called as continuing guarantee, okay। So continuing guarantee ये है कि when you give a, ठीक है, कई बार में ये होगा कि ये जो है हमारे the इन दिस केस इस बॉन्ड के लिए श्योरिटी हैज गिवन अ गारंटी. ओके, सो दिस इज लाइक गारंटी फॉर अ सिंगल इंस्टेंस. ठीक है, अगर यही श्योरिटी बोलता है कि इन अ पीरियड ऑफ 1 ईयर, ठीक है, पीरियड ऑफ 1 ईयर में वॉट एवर बॉन्ड, ओके, द प्रिंसिपल डेटर साइंस, आई गारंटी इट. ठीक है, अंडरस्टूड. यहाँ पे क्या हो रहा है, ये बोल रहा है पीरियड ऑफ 1 ईयर तक मैं गारंटी देता हूँ, नॉट जस्ट फॉर दिस बॉन्ड. तो इट दैट इज कॉल्ड अ कंटिन्यूइंग गारंटी. यानी 1 साल में इफ ही हैज ड्रॉन, ये जो बॉन्ड है बिटवीन प्रिंसिपल डेटर एंड क्रेडिटर, ठीक है, इफ क्रेडिटर हैज ड्रॉन इवन से 50 बॉन्ड्स इन 1 ईयर, okay, surety will be liable for all 50 bonds. ठीक है, that is called a continuing guarantee. Okay, so this is a guarantee which extends to a series of transactions. Example देखेंगे. A in consideration that B will employ C in collecting the rents of B's zamindari. Okay, so ठीक है, यहाँ पे सेंटेंस को आपको बड़े केयरफुली पढ़ना है, राइट. तो जो जो some sentence are in passive voice, ठीक है, तो देन कभी कभी यू माइट हैव अ डाउट कि इसमें क्रेडिटर कौन है, डेटर कौन है. ठीक है, सो केयरफुली इफ यू रीड यू विल बी एबल टू गेट हु इज डेटर, हु इज क्रेडिटर, हु इज श्योरिटी. ओके, A in consideration, so A has got a consideration that B will employ C. ठीक है, so यहाँ पे पता चल गया B will employ C in collecting rents. ठीक है, so B is creditor. ठीक है, और C is the principal debtor. ठीक है, B is creditor, C is the principal debtor. ठीक है, so A in consideration that B will employ C in collecting rents of B's जमींदारी, ठीक है, promises B, यानी ये सेंटेंस क्या हो गया, A promises B. ठीक है, A, ठीक है, promises B, तो बीच में जो कॉमा के बीच में जो भी है that is just extra thing. A promises B to be responsible, ठीक है, to the amount of 50,000 for the due collection and payment by C. ठीक है, so मतलब यहाँ पे क्या हो रहा है, B is a जमींदार. ठीक है, B is a जमींदार and A is saying, ठीक है, यहाँ पे आपका B is a जमींदार. ठीक है, and B, okay, B wants to employ C but he needs a guarantee because he is employing him for collecting rents, so there is a chance that a new person can collect the rent and run away, so he is looking for guarantee. So our A is now guaranteeing him. ठीक है, how much is guaranteeing him, okay, to the amount of 5,000. okay, ठीक है, up to 5,000 के लिए he is guaranteeing, okay, for the due collection and payment by C of those rents. ठीक है, ठीक है, तो up to 5,000 he is guaranteeing that whatever he collects up to 5,000 I will guarantee his say. ठीक है, so he might go and collect any number of times, correct, till it reaches 5,000 A will be responsible. ठीक है, so it becomes more than one occasion. ठीक है, और दूसरा एक तो हो गया more than one occasion. Second is if he is giving a job for collecting rents then it will be regular. ठीक है, यहाँ पे ये नहीं लिखा है कि सिर्फ मैं पहली बार ही आपको दूंगा करके. ठीक है, ये कंसिडरेशन, ये मैं सिर्फ 1 महीने के लिए आई एम गारंटिंग, इट्स नथिंग लाइक दैट. ओके, ऐसा कहीं नहीं लिखा है. सो दैट्स व्हाई इट इज अ कंटिन्यूइंग गारंटी, क्योंकि बहुत सारे इंस्टेंसेस इन्वॉल्व. हो सकता है 5,000 में हो सकता है वो 20 कलेक्शन कर ले, करेक्ट, सो विच इज व्हाई इट इज अ कंटिन्यूइंग गारंटी. जस्ट रिमेंबर इफ इट इज मोर देन वन टाइम्स इट बिकम्स अ कंटिन्यूइंग गारंटी. ओके, ठीक है, इट इज सिंपल टू आइडेंटिफाई अ कंटिन्यूइंग गारंटी. चलिए, ए गारंटीज पेमेंट टू बी अ टी डीलर अमाउंट ऑफ 100. ठीक है, सो ए इज गारंटिंग, सो ए इज श्योरिटी. ठीक है, इज गारंटिंग टू बी, यानी बी इज क्रेडिटर. इतना क्लियर, राइट. बी इज अ टी डीलर बताया हमको. is guaranteeing B amount of up to amount of 100. ठीक है, for any T he may time to time supply to C. ठीक है, मैं बोल रहा आप C को आप टाइम टू टाइम, जैसे टाइम टू टाइम मीन्स एवरी मंथ एवरी क्वार्टर, ऐसा कुछ, okay, some period. So that for that period he is saying that up to 100 rupees I am guaranteeing. ठीक है, 100 रुपीज तक गारंटी, अगर उसने नहीं दिया तो मैं दूं, इफ ही डजंट पे देन आई विल पे अप टू 100. ओके, फ्रॉम टाइम टू टाइम, that means let us say every month he might have guaranteed, it will be some period. Okay, so every month that guarantee will run, so it is very clearly a continuing guarantee. Okay, so 100 is there. So and C pays, so ठीक है, for any T he may from time to time supply to C. So B supplies C with T, ठीक है, T to above the value of 100 and C pays. ठीक है, फिर क्या हुआ, once C has paid the amount, ठीक है, afterwards then B again has supplied CT with the value of 200. Second time C didn't pay, ठीक है, but the guarantee was continuing because he said that if he didn't pay, if he defaults, I will pay 100. So then because he has now bound himself with 100, ठीक है, इसलिए चाय वाला जो है 100 रुपए से ऊपर नहीं मांग सकता, just bound himself with 100. Okay, guarantor will determine his liability always, correct? The guarantor has expressly said that up to 100. So is 200 में से he will pay the tea dealer 100 rupees. Okay, and 100 rupees will be the loss of tea dealer. Okay, ठीक है, so this is also an example of continuing guarantee. ठीक है, this contract act is little long but not difficult to understand, but you will have to go through the lectures one fully because all these sentences have meanings hidden. Okay, ऐसा नहीं हो सकता कि मैं, it's not really possible that we just talk about important points, then you will not be able to decipher the meaning. जैसे ये examples को देखिए, you will get examples like this. Okay, unless you read these sentences, will not, and you know how to read and take out the meaning of these sentences. ठीक है, so तब तक आप, you will not be able to write the answer. Okay, even if you know the concepts. इसीलिए that's why we are going in detail. Right? So चलिए, guarantee was a continuing guarantee and hence he is liable to the extent of 100. Okay, चलिए, then let's say one more example. A guarantees payment to B. A is the guarantor, B is the guarantor मतलब surety, right? So and B is the creditor. Okay, of the price of 5 sacks of flour to be delivered to B to C and to be paid for in a month. ठीक है, see here it is one occasion, it's very clear in the sentence, is guaranteeing price of 5 sacks of flour. Okay, ठीक है, flour मतलब यहाँ पे जो FLOUR flour होता है, इसको you pronounce it as flour and it is जो गेहूं का आटा जो बनता है उसको बोलते हैं. ठीक है, flour. ठीक है, किसी का भी हो सकता है, चावल का भी हो सकता है, नॉर्मली जो ओके गेहूं का आटा होता है. So 5 sacks of flour to be delivered to B. ठीक है, to ठीक है, delivered by B to C. ठीक है, ये यहाँ पे to B नहीं होना चाहिए, यहाँ पे should be by B. ठीक है, delivered by B ठीक है, by B to C. So ये बोल रहा है कि I am guaranteeing payment of price of 5 sacks of flours which you are delivering to C. ठीक है, और एंड टू बी पेड फॉर इन अ मंथ, मतलब 1 महीने में दाम नहीं दिया तो मैं दूंगा. ठीक है, या कहीं भी ऐसा लग रहा है आपको कि ही इज सेइंग दैट एवरी मंथ और सम एवरी पीरियड दैट यू डिलीवर 5 sacks आई एम गारंटीइंग इट. नो, इट इज ओनली फॉर दिस ओकेजन. इट्स वेरी वेरी क्लियर है. ठीक है, बहुत साफ है कि ये एक वन टाइम गारंटी है. अभी जो आप 5 sacks ऑफ फ्लावर दे रहे हो, उस अगर 1 महीने में वो नहीं देता है आपको तो मैं दे दूंगा पैसे. ठीक है, अब अगले बार फिर से अगर उसने डिलीवर किया तो मेरी जिम्मेदारी नहीं, राइट? It is very clear here. This is not a continuing guarantee. So now first one, B delivers 5 sacks, ठीक है, और C pays, यानी जो debtor है, he has paid. Now second time guarantee was only for one time. Afterwards, B delivers 4 sacks to C, ठीक है, which C does not pay for. Afterwards 4 sacks दिया, इस बार debtor ने नहीं दिया पैसे, he has not paid for. Now the guarantee was not a continuing guarantee and surety is not liable to pay for this. ठीक है, चलिए, a guarantee may either be restricted to a certain debtor or a certain amount, or it may be continuing. ठीक है, guarantee may either be restricted to a certain debtor. ठीक है, आप कई debtors में से you are only saying I am guaranteeing for only for this person. ठीक है, can be restricted to a certain debtor or to a certain amount. आप बोलेंगे certain debtor, certain amount. I am guaranteeing only 100 rupees, like the tea dealer, or it may be continuing guarantee. ठीक है, so if the liability extends to a single transaction, ठीक है, it is specific, और उसको बोलेंगे हम specific guarantee. ठीक है, so after उस particular instance का payment हो जाए, फिर guarantee नहीं रह जाता, like we saw in sacks of flour. okay, चलिए, अब हम देखेंगे कि how to revoke a continuing guarantee. See, okay, you have given a continuing guarantee, but now you don't want to be liable because now you think that that person is no longer reliable. Okay, there should be something by which you can revoke a continuing guarantee. So how to revoke and what are its effects? ठीक है, तो कैसे revoke किया जाए, यानी कैसे वापस लिया जाए continuing guarantee. Okay, continuing guarantee can be revoked by two ways. Okay, can be revoked by two ways. One is revocation by surety. Surety can revoke it. ठीक है, and second is revocation on the death of surety. ये दो ही cases है for revoking continuing guarantee. Okay, let's see first revocation by surety. Okay, it may be revoked by the surety as to future transactions by notice to the creditor. ठीक है, ये याद रखना. So it can be revoked as to future transactions. ठीक है, जो पहले आपने गारंटी दे चुके हो, for that you are liable. Whatever guarantee you have given, that you are liable. But as to future transactions, you can revoke. ठीक है, यानी फ्यूचर का जो गारंटी है वो आप रोक सकते हो, नॉट द पास्ट. ठीक है, एंड यू कैन रिवोक इट बाय नोटिस टू द क्रेडिट. ठीक है, सो एग्जांपल लेते हैं. ओके, A in consideration of B's discounting at A's request. ठीक है, so यहाँ पे A is the surety. Okay, and in consideration of B's discounting at A's request, A has requested B to discount bill of exchange for C. ठीक है, so he guarantees to C. ठीक है, A is guaranteeing to B. ठीक है, तो कोई भी ऐसा पढ़ना है आपको, या if you get big sentences in commas like that, so just read it like this. ठीक है, A, okay, फिर यहाँ पे सभी आ जाएगा something in consideration of B's discounting bills of exchange for C. ठीक है, ये सब है, ignore this and then see the next comma, guarantees to B. So A guarantees to B, A is surety, B is creditor. ठीक है, and C is the debtor. ठीक है, इसमें you have to be more alert because normally कई चीजें आपको मिलेगी where C stands for creditor, C में creditor रहेगा, लेकिन एग्जाम में they can give anything. See, for in this example C is the debtor. ठीक है, so be very careful first to find out who the parties are. ठीक है, कौन parties हैं वो हमको पहले carefully find out करना है, right? Okay, so then so यहाँ पे क्या है, A is the surety, okay, B is the creditor, C is the debtor. ठीक है, so क्या बोल रहा है कि what A is say asking B that you discount bills of exchange of C. बिल डिस्काउंट करके दे दो. Okay, if he dishonors I will pay. Okay, ठीक है, फॉर 12 months. Okay, guarantees for 12 months. It is a continuing guarantee, right? ठीक है, the due payment of all such bills. Guarantees for 12 months, due payment of all such bills. ठीक है, to the extent of 5,000. So ये continuing guarantee. जब एक लंबा पीरियड मिल गया, then it is a continuing guarantee. ठीक है, इस बीच में whatever bills he will discount, A will be the guarantor for that surety. Okay, total amount is 5,000. ठीक है, B discounts bill for C to the extent of 2,000. ठीक है, afterwards at the end of 3 months A revokes. तो यहां पे क्या हुआ, for 3 months he held the guarantee. After 3 months he has revoked. So in that 3 months period, whatever bills were discounted, A will be the guarantor for that. ठीक है, past का सब A will be the guarantor, but future he will not be guarantor. After 3 months, whatever bills have been discounted, for that A is not liable. Okay, so यहाँ पे the revocation discharges A from all liability to B for any subsequent discount, for any future discount. ठीक है, future discounting, any subsequent discount. ठीक है, लेकिन past के सारे जो है before revoking जितने भी ये whatever transactions have taken place, he will be a guarantor for that. ठीक है, so इसीलिए क्या होता है यहाँ पे, B A is liable to B for rupees 2,000 on default of C. ठीक है, ये 2,000 तो पहले ही हो गया ना, then he has revoked, so for this 2,000 he will be the guarantor. Okay, चलिए next, A guarantees B to the extent of 10,000. A guarantees B to the extent of 10,000. ठीक है, that C shall pay all the bills. Okay, A guarantees to B to the extent of rupees 10,000. ठीक है, A is the surety, B is the creditor, or limit is 10,000 for surety. Okay, that C shall pay all the bills that B shall draw upon C. यानी ठीक है, C जो है वो सारे बिल्स पेबल पे करेगा करके, दैट मीन्स नहीं करता है तो इज गारंटिंग टू द एक्सटेंट ऑफ 10,000. ओके, ठीक है, C accepts the bill. Okay, B gives notice of revocation. After accepting, he has given notice of revocation, but he will be held responsible for this 10,000. C dishonors the bill at maturity. A is liable on his guarantee. Okay, because before he revoked, okay, this transaction took place for which he guaranteed. ठीक है, ये हो गया past guarantee, so he will be liable. Fine, बस इतना याद रखना है इसमें आपको, जो past guarantee है that will stay. Future, in case of revocation of continuing guarantee, what will happen is past guarantee will stay, future guarantee जो है that will be stopped. ठीक है, fine, ठीक है, तो continuing इसलिए था क्योंकि to the extent of 6,000 C shall pay all the bills that B shall draw upon C. ठीक है, तो ये सारे बिल्स को उसने बोला है बेसिकली. तो वॉट एवर टू द एक्सटेंट, यहाँ पे डिटेल्स दे हैव नॉट गिवन टू हाउ मच एक्सटेंट ही हैज एक्सेप्टेड. ओके, टू दैट एक्सटेंट it will be A the surety will be liable. Okay, चलिए next is revocation of continuing guarantee by surety's debt. Two types of revocation were there, right? One is by surety, second is by surety's death. Death of surety operates in the absence of any contract to the contrary. If there is no contract to the contrary, death of the surety operates as a revocation of the continuing guarantee. As a revocation of the continuing guarantee so far as regards future transactions. ठीक है, तो अगेन अगर उसका डेथ हो गया, ऑटोमेटिकली इट इज अ रेवोकेशन ऑफ guarantee for future transactions. ठीक है, even in death, past remains. ठीक है, तो दोनों में सेम ही चीज हो रहा है एक्चुअली इन बोथ द कंडीशंस. ओके, नेक्स्ट इज डिस्चार्ज ऑफ श्योरिटी. ठीक है, नेक्स्ट वी आर टॉकिंग अबाउट व्हाट, डिस्चार्ज ऑफ श्योरिटी. ठीक है, लेट्स डू वन थिंग, विल टेक अ ब्रेक. ओके, लेट्स बी बैक. 7:30. ओके, ठीक है, बैक एट 7:30 PM. Okay, so welcome back. We will continue from where we left. So discharge of surety. Okay. So liability of the surety is discharged under the following circumstances. So discharge means he will no longer have his liability. Okay. So he can end his liability by giving notice to the creditor. Okay. By death of surety also it will go. So these two things we have already seen above. And other than that, there are by variance in terms of contract. Okay, variance in terms of contract. So if the contract between principal debtor and creditor are varied without telling the surety, then his contract is automatically discharged by release or discharge of principal debtor. So the creditor is releasing the principal debtor or discharging. Okay, then when creditor compounds with the principal debtor, okay, by giving time or agrees not to sue principal debtor. Okay, so when creditor and principal debtor, they have some, you know, kind of design between them so that they can, get more money from the guarantor, something like that. Okay, so that is called compounding. So both of them are colluding. Okay, so whatever some terms and all by which the debtor is bound, the creditor is relaxing them. Okay, without telling the surety. So then he can, then surety's liability is no longer there after that. Okay, by creditor's act or omission impairing surety's eventual remedy. Okay, this creditor is doing something by which whatever is creditor's remedy, creditor is liable to get back money from debtor. Okay, so sorry, surety can get back the money from debtor eventually after paying the guarantee money. The creditor is doing something by which now debtor will not be able to pay creditor, something like that. Okay. So in that case, surety doesn't have anything to do with the creditor. Contract no longer is there. So these are the points for discharge of surety. Okay. We had discharge of surety ke points. So we'll just see it more. Liability of the surety is not considered to be discharged. ठीक है, कब liability of surety is not getting discharged? ठीक है, when a contract to give time to the principal debtor is made by the creditor, and contract to give time to the principal debtor is made by the creditor with a third person, ठीक है, not with the principal debtor. So जब principal debtor and creditor are colluding, ठीक है, only then surety is discharged. ठीक है, the contract to give time to principal debtor is made by creditor with a third person, then there is no effect. Okay, then surety's contract stays. Mere forbearance on the part of the creditor to sue principal debtor or to enforce any other remedy. Okay, so if the creditor debtor has defaulted, but the creditor is not suing him immediately, is just waiting for some time, that doesn't discharge the surety. Okay, now see an example. B owes C a debt guaranteed by A. Okay. B owes to C a debt guaranteed by A. Here again see the sentence closely. So the guarantor or surety is A. And B is owing some amount. So B is the debtor. Here C is the creditor. Okay. The debt becomes payable. C does not sue B for 1 year. So the surety is not discharged just because he is not sued. Okay. Now we'll talk about, we spoke about discharge of surety. Now we'll talk about rights of surety. Okay. Right of surety on payment or performance. He gets all rights which creditor had against principal debtor. So once he has paid, surety has paid the money to creditor, all rights of creditors become rights of the surety. because the creditor has now moved. Old creditor is cancelled and surety has become creditor. So whatever rights the old creditor had, okay, that will become rights of the surety. A surety is entitled to the benefit of every security which the creditor had against the principal debtor at the time of contract of suretyship, whether the surety knows it or not. And if the creditor loses or without the consent of the surety, parts with such security. Surety is discharged to the extent of security. What does this sentence, this whole thing means? Okay, so if your creditor had any security, okay, as soon as surety has paid the amount, the security should move to surety because he has become creditor. Okay, and if the creditor doesn't give it to the surety and see he sells it off, okay, and retains the money, then the surety does not have to pay to the creditor to the extent of that security. Okay, right? So for example, I'll tell you one example. Here we have a surety. Okay, here we have a creditor. Okay, and here you have a principal debtor, PD. Okay, so now creditor, see the guarantee is for rupees 5,000. Okay, creditor had a security. Okay, creditor had a security also, right? So this principal debtor defaulted. The surety now has paid 5,000 to the creditor. Okay, so and what the creditor is supposed to do is he has to give the security to the surety. But what he has done, he has sold this off. Okay, he has sold off the security and got 2,000. Let us say. Okay, he has got 2,000. Okay, so if he has sold the security and got 2,000, and the surety's liability will only be 3,000. Okay, and say if he has already paid, then the creditor will have to give back this proceeds to surety. Okay, so that is the meaning of this sentence. ठीक है, clear? तो ये एक और एग्जांपल देखते हैं कुछ. After these examples आपको काफी comfort आ जाएगा. Okay? C advances to B his tenant rupees 20,000. Okay, C advances to B his tenant. So B is the tenant of C and C is advancing money. So C is creditor, B is principal debt. How much money is advanced? 20,000. On the guarantee of A. Okay, surety is A. C has, the creditor has also a further security of 20,000 by mortgage on B's vehicle. So he has a security of 20,000 also. Okay, so C cancels the mortgage. So if the security is there at the time when the guarantee agreement was signed, whatever security is there before that, okay, that will become the security of the surety on payment of guarantee amount. So anything which is any security which he is getting, the creditor is getting after the date of guarantee agreement in future, okay, that that he need not give to the surety. Okay, only anything which is on or before the date of surety agreement, before the date of surety agreement. Now C cancels the mortgage. Okay, B becomes insolvent. Okay, and C sues A on his guarantee. A is discharged from liability because why? Because he should have given the security to A, the surety. Okay, but what he did is he has cancelled the mortgage, right? So if B if B had to pay the guarantee amount of 20,000, he has the right to take up this security. Okay, that's why now, because he has cancelled the security, now he doesn't need to pay any amount because his liability will be 20,000 minus 20,000. Had this amount been 15,000, okay, then surety would have to pay only 5,000, 20,000 minus 15,000. Okay, right. Then C, a creditor whose advance to B is secured by a decree. Okay, decree is like a legal by law. Okay, by law you can say. So C, a creditor whose advance to B is secured by a decree. Okay, an agreement which is through law, a legal agreement kind of. Okay. Yeah, C is creditor here. This is clear. Whose advance to B? B is debtor, secured by a decree, means a legal agreement. Okay, receives also a guarantee for that advance from A. So guarantee is received from A. Okay. C afterwards takes B's goods in execution under the decree. So as per the decree, okay, it's like a legal agreement. Okay. So if he would have defaulted, if B would have defaulted, then the decree can give power to C to take possession of some of his goods. Okay. So C afterwards takes B's goods in execution under the decree. Okay. So kind of we are saying goods in execution means japt karna. Okay. So C has got it in japti, B's goods. Okay. Under the decree. So now without knowledge of A, withdraws the execution. Okay. So now if he had a decree further secured by a decree, okay. So this is like a security. Okay. So if so he could not have discharged him without asking the surety. Okay, because when surety's liability was there to pay back the amount, he also had the right to own the decree now. Whatever things he could have got by the decree, that would have been A's now, the sureties. ठीक है, same example है जो मैंने आपको पहले दिया था. Okay, fine. So the next is A as surety for B. Okay, so A is surety. Okay, for B means creditor, makes a bond jointly with B to C. Okay, jointly with B to C, A is making a bond to secure a loan from C to B. Okay, so he has secured he has got a loan. Okay, he's got a bond to secure a loan from C to B. Okay, he's got a bond. अब ये bond now is what? ठीक है, bond is an asset, तो ये हो गया security अभी. ठीक है. Afterwards, C obtains from B a further security for the same debt. Okay, what I said is any security obtained after the date of guarantee agreement. Okay, your creditor has no liability to give it to the principal debtor. Okay, it's only before the surety agreement. So afterwards, C obtains from B a further security. Subsequently, C gives up further security. A is not discharged. So he can, for the further security, has no liability to give it to the surety. Okay, hence he is not discharged. ठीक है, चलिए next हम देखेंगे something which is called as subrogation, where the guarantor clears his liability by payment. Okay, subrogation where the guarantor clears his liability by payment. Now, surety is invested with all rights which the creditor had with the principal debtor. Okay, this is what I told you, that after paying the money, After paying the guarantee amount to the creditor, surety gets all the rights which the creditor had with the principal debtor or against the principal debtor. Conditions. Okay. The debt must have become due or the principal debtor must have made default. Okay. Debt must, just a debt becomes due. Okay. Or the principal debtor must have made a default. Okay. There must be a default from the principal debtor. Surety must have paid the whole debt or must have performed all that he is liable for. Surety has paid his guarantee amount fully, whatever he had to. Okay. Unless there is unless these two conditions are fulfilled, there can be no subrogation. ठीक है. तो subrogation basically is what here? यहाँ पे जो है इस चीज को हम subrogation बोल रहे हैं. That subrogation का actual meaning जो होता है, जैसे I had told you earlier when we were doing earlier provisions, it is substitutions. ठीक है. Substitution. So here what is happening? Creditor's power against the debtor is moving out from him and he is going to, it is going to surety. Okay. It is going to surety now. So surety is substituting the creditor now, correct? That is called as substitution or subrogation. It can happen only when these two things have happened. Okay. Principal debtor must have paid the whole debt. Okay. Whatever he was bound to perform, he has performed fully. Okay. Debt must have become due. Okay. And after that, he would have paid. Okay. And the principal debtor must have made a default. Because he has made a default, that's why surety is paying the amount. Correct. So that is about subrogation. Okay. So invalid guarantee. Following are considered as invalid guarantee. Okay. If you've got a guarantee by misrepresentation, creditor has made some misrepresentation. Okay. Or creditor has caused the guarantee to happen through misrepresentation. Okay. Through someone else. Okay. So then guarantee will become invalid. Okay. And this should be for a material part of the transaction, right? And guarantee obtained by concealment means silence. Guarantee obtained by concealment. Okay. In these two cases, so in short, guarantee obtained by misrepresentation or by silence or concealment. Okay. Then the guarantee becomes invalid if creditor uses any of these two means. Okay. Then some examples for this. A engages B as clerk to collect money for him. Okay. Now B is clerk, A has engaged him. B fails to account for some of his receipts. Okay. So B has not given him all receipts properly. Okay. And A in consequence, what he has done is calls upon him to furnish security. He says, you furnish security, only then I will keep you for job because I don't trust you fully. C gives his guarantee. So for security, what he has done is he has brought a guarantor. So C gives his guarantee for B's duly accounting. Okay. Now A, the creditor, does not acquaint C with B's previous conduct. He did not tell him that, oh, he did not, he did some embezzlement. Okay. That he did not, whatever he collected, he did not give me full money. So his conduct, okay, should have been appraised. But A did not do that. Okay. A did not acquaint C with B's previous conduct. B afterwards makes default. So guarantee is invalid. Okay. He has concealed something, correct? So guarantee is invalid. Right? Guarantee is invalid means guarantor doesn't have to pay anything. A guarantees to C payment for iron to be supplied by him to B to the amount of 200 tons. Okay. A guarantees C. A is the surety. C is the creditor. Okay. Payment for iron, okay, to be supplied by him to B. B is the debtor, to the amount of 200 tons. So 200 tons of iron he has guaranteed. Okay. Now what have B and C have privately agreed that B should pay rupees 5 per ton beyond the market price. Okay. And such excess will be applied in liquidation of an old debt, that is payment of an old debt. So now what they have done is, the creditor and the debtor is saying that we have guarantee for 2000 tons. What you do is, okay, quote price 5 rupees more per ton. So when I default, okay, we will get the whole money from him. And whatever extra 5 rupees per ton we are getting, this I will use to repay an old debt. So this is cheating against the surety, right? So agreement is concealed from A. A is not liable as surety. Okay. The next is co-surety. Okay. Co-surety is when there are more than one surety. Okay. So where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in as co-surety, guarantee is not valid if other person does not join. Okay. So if guarantee has been given stating that only if someone else joins, only then I am guaranteeing. Then if the other person doesn't join, guarantee is not valid. Okay. Co-sureties are liable to contribute equally. Okay. Also to pay other co-surety an equal share of the whole debt. Okay. Or of that part of which remains unpaid by the principal debtor. So they have to basically they have to pay equal share of the whole debt, all co-sureties. Okay. Right. So co-sureties who are bound in different sums. Sometimes it is possible that one co-surety is bound for 20,000, another one is bound for 1 lakh. That is happen. That is possible, right? So co-sureties are bound in different sums are liable to pay equally as far as the limits of their respective obligations permit. Okay. So this we will see by an example, you will understand better. Okay. So are bound in different sums. If they are bound in different sums, then how will we take the payment from them equally? Okay. That procedure we will see. That is, they will pay equally as far as limits of their obligations permit. Okay. So let's see this example, you will understand. A, B, and C are sureties for a D. 3 co-sureties are there, A, B, and C. Enter into 3 several bonds, 3 bonds, each in a different penalty. Okay, namely A in the penalty of 10,000, B 20,000, C 40,000. So penalty basically means here this is the guarantee amount. Okay, the sureties have entered 3 bonds guaranteeing 10,000, 20,000, and 40,000. Okay, condition for D is duly accounting to E. Okay, E is the creditor. Okay, D is the principal debtor. D makes default to the extent of 30,000 rupees. Now default is 30,000 rupees. So what you should do is, okay, first just take the default amount. Okay, take the default amount. The default amount is here 30,000. Number of sureties is 3. So divide this by 3 to get individual amount. Now this is 10,000. Okay, this comes as 10,000. So now 10,000 does anyone have a limit which is less than 10,000? No. This is 10,000, this is 20, 40. So here all 3 will pay equally. All 3 will pay 10,000 rupees. Okay. This is how you will have to do. So take the total liability. 30,000 was the liability. 3 co-sureties are there. Divide by 3 and see if it is within limits of all 3. Okay, if it is within limit of all 3 will pay equally. If say this is less, this was not 10,000, this was only 5,000. Okay, is limit. Okay, then 5,000 is less than 10,000. First one will pay only 5,000. Okay, then first one will pay only 5,000. So how it will happen is first one pays 5,000 because that is his limit. You cannot take 10,000 from him. What is the balance? 25,000. And how many are the remaining surety? 2. So now 25,000 upon 2 is 12,500. This much these two will have to pay. So see if 12,500, if their liabilities are less than 12,500. Answer is no. One is 20,000, one is 40,000. Okay. So both of them will pay 12,500 each. So how total will be paid? First one will pay 5,000. Second one will pay 12,500. Third one will pay again 12,500. Okay. Add this, it will be 30,000. Fine. So this is how liabilities will be determined. So now the second one, you see, you will understand more. This is the second one. A, B, and C as sureties for D. Okay. A, B, and C as sureties for D. Enter into 3 several bonds. Again, same. Okay. This is the same. Problem remains the same. Okay. Just, yeah. So this problem is exactly, okay, same. Everything is same. A, B, and C as sureties. 3 several bonds. And the penalty, which is guarantee amount, is also same for all 3. Okay. So here only the debt will be different. Okay. So this is also same. And E makes default to the extent of 40,000. Earlier they said 30,000. Now they have given us 40,000. Okay. So, so let's see how we will get it. Okay. 40,000 is the default now. Come here. So just take 40,000. Okay. How many sureties? 3. Divide by 3. Okay, each one has 13,333 is the liability. Okay, so is anyone's liability less than that? Yeah, 10,000 is less. Okay, so take 10,000 from him. You can't take more than that. Okay, because he has undertaken to give you only 10,000. Can't take more than that. So now what we will do is take only 10,000 from the first one. What is the balance now? 30,000 is the balance. Okay, now there are 2 sureties left. Each one will pay 15,000. Just see if the amount which they have to pay, is it less than 15,000? Okay, let's see. It's 20 and 40,000. So we are fine. Okay, so that's why one person will pay 10,000, 2 people will pay 15,000. Okay, right? In this case, so 10,000, 15,000, 15,000. Okay, total is 40,000. Got it? Fine. So that's to pay 10,000 and B and C 15,000 rupees. Okay, this is how it is calculated. A, B, and C as sureties for D. Okay, same problem is same again. Okay, we need not read it. Same thing is there. Okay, this is also same, right? But only difference is here it was 40,000. Now default is 70,000. Just to explain you. Okay, default now is 70,000. I mean, if it is 70,000, let us again try to find out. Okay, let's say 70,000. Okay, is the amount required now. 3 sureties are there. So it will be how much? 70,000 upon 3, 23,000. Right? Now one has 10,000, we already know. Okay, so let's just give his 10,000 straight away. The remaining is 60,000. Okay, now 60,000 is for 2. Correct? For 2 people. So this is now 60,000 upon 2 is 30,000. But now the second one is 20,000. Correct? Second one is 20,000 here. Isn't it? Here. So now he cannot pay 30,000. Correct? So now again you will have to use only 20,000 from the second person. And now just find out how much is left is 40,000. Now there is only one surety and amount is 40,000. His liability also is to the extent of 40,000. So he will pay the whole amount. Okay. So if you add these, what will happen is one person has paid 10,000, 10,000, second one has paid 20,000, third one has paid 40,000 in this case. Okay. C will have to pay full penalty of his bond list, 40,000. Okay. Right. So then next point here is implied promise to indemnify surety. Okay. This point talks about that principal debtor has the liability to indemnify surety in future. Okay. Because surety is paying on his behalf, right? So in every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. Okay, it's always there. He has to indemnify the surety. Surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but no sums which he has paid wrongly. Okay, all sums which he has paid he can recover, but not any sums which he has paid incorrectly. Okay, so in this example, you will get that B is indebted to C and A is surety. Okay, so C is creditor, B is debtor, A is surety. Okay, C demands payment from A. Okay, A the surety, and on his refusal, he sues him. The surety doesn't pay, so he sues him, creditor. Okay, A defends the suit. The surety defends the suit, and he has reasonable grounds. He did not pay because there is something wrong in the claim. Okay, so having reasonable grounds for doing so. Okay, but he loses the case and he has to pay the debt with cost. Now, because he had reasonable grounds for not paying, so now the principal debtor will have to pay the surety both the amount of the debt plus the costs of the suit. Okay, he can recover from B the amount paid by him for costs as well as the principal debt. Okay, because the defense which he did, it was reasonable. If it was not reasonable, then he did not give the suit amount, but he has to give the debt amount anyways. Okay, here is the second one. C lends B a sum of money. Okay, and C lends B a sum of money. C is creditor, B is debtor. A, at the request of B, accepts a bill of exchange drawn from B upon A, okay, to secure the amount. Okay, C is the holder of the bill, right? So now they have just given a bill to C. Okay. Okay, so they have given a bill basically here to the creditor, right? So now C, the holder of the bill, the creditor is the holder of the bill, demands payment from A. So basically, A is the surety, okay, and A is the surety, and B has drawn a bill on A, kind of an accommodation bill, you can say, and that bill has been endorsed to C here. Okay. So here now C is the holder of the bill, creditor has that bill, he demands payment from the surety. Okay. Surety refuses. Okay. Then creditor sues him, but he doesn't have reasonable grounds. Okay. And then he has to pay the bill plus cost. Because he did not have reasonable grounds, okay, he can recover from the principal debtor only his debt, whatever is the debt amount which he has paid. Okay, not the suit costs. Okay, right? So he can, so yeah, in the previous point what I've explained, this is the same thing. Okay, so we can now, the thing is like, see, your surety, okay, and principal debtor. Okay, and here is your creditor. So on default, surety has paid money to the creditor. Okay, paid 50,000 to the creditor. So now 50,000 is the debt of principal debtor. Principal debtor will have to pay surety in future. Correct, right? So if say uh, there is something, say the creditor, now there is a contract between surety and creditor. So creditor can directly sue surety. Correct. So if creditor sues surety and he has defended the case, okay, if he has defended properly, that is there was some point on which he has defended, okay, and then case cost is the 10,000. Now he can recover total 50,000 from principal debt, but he has defended, and that case he was going to lose anyway. Just for the sake of it, he has put the case. Okay, then he will not get this case cost, but he will get his the debt amount from the principal debt. Okay. A guarantees to C to the extent of rupees 2,000 payment for rice to be supplied by C to B. A is the surety, C is the creditor, extra to the extent of 2,000 payment for rice to be supplied by C to B. Okay. So now B is the principal debtor. So C supplies to B rice of a less amount than 2,000. Okay. But obtains from A payment of 2,000. Right? He cannot do that. So if he has supplied rice for a less amount than 2,000, okay, and say there has been a default, then he can obtain only that amount which he has supplied. Correct? If he has supplied for 1,500, he can only get 1,500 from the guarantor. Here what happened? He has obtained the full amount. Okay. So A cannot recover from B more than the price of the rice actually supplied. Okay. He can only recover in case of default. Okay, only the real price of the debt. Okay, not more than that. Okay. Okay. So now next sub point which we are going to start, it is bailment and pledge. Okay, it's called as bailment and pledge.